Good evening, everyone. I'm Rita Shackle. I'm the Interim Dean and Head of School of the Sydney Law School, and I thank you all very much for your patience and your flexibility this evening. It's my absolute pleasure to welcome you all to the Law School this evening and to this public lecture and discussion on a Human Rights Act for New South Wales. And as I welcome you to this beautiful place this evening, I would like to acknowledge the traditional owners of country, the Gadigal people of the Eora Nation, and pay respect to all elders. The opening remarks for this discussion this evening will be offered by Dr. Ruth Higgins, Senior Counsel and President of the New South Wales Bar Association. Dr. Higgins is a commercial and public law silk practicing nationally. Ruth is a member of the Takeovers panel and a director of the Australian Bar Association, a fellow of the Australian Academy of Law, an assistant general editor of the Australian Law Journal, and a fellow of the Australian Centre for International Commercial Arbitration. Thank you, Ruth, and I'd like to invite you, to make your opening remarks.
I too acknowledge the traditional owners of this land, the Gadigal of the Eora Nation, and I give my respect to their elders past and present. I acknowledge all First Nations people present this evening. Sincere thanks for your welcome, Professor Shackle, and thank you to the University of Sydney Law School for hosting this public lecture, A Human Rights Act for New South Wales. The New South Wales Bar Association is a member of the New South Wales Human Rights Act Alliance and is proud to present this lecture tonight with the Alliance. We're also delighted to be joined by current and former judicial officers, members of the New South Wales Government and New South Wales Parliament, the New South Wales Women's Safety Commissioner, Dr. Hannah Tonkin, the Dean and former Deans of the University of Sydney Law School, and representatives of many organisations who have played a leading role in advocating for greater protection of human rights in New South Wales and Australia. Human rights recognise the inherent value of each person, regardless of background, where we live, what we look like, what we think, or what we believe. They are inalienable, interrelated, and interdependent. Australia was one of 8 nations involved in the development and drafting of the Universal Declaration of Human Rights, adopted by the United Nations General Assembly in 1948. And yet, despite this, the protection of human rights in Australia, and in New South Wales in particular, is fragmented and ad hoc. That is acutely so for the most disadvantaged members of our community, as we'll hear from our panellists this evening. Australian law does confer certain limited protections on human rights. There are limited constitutional protections for certain civil and political rights, such as the right to vote, trial by jury, and freedom of religion. Certain protections are provided by the common law, such as the right to a fair trial and the principle of legality. A range of federal and New South Wales statutes protect against discrimination, most notably for today's lecture, the Anti-Discrimination Act 1977 of New South Wales. And of course, independent bodies such as the Australian Human Rights Commission play a critical role. But it is to some extent a mosaic of missing pieces. As the Federal Parliamentary Joint Committee on Human Rights stated in May of this year, our current piecemeal approach to human rights protection is not adequate to ensure rights and freedoms are properly respected, protected, or promoted. The Joint Committee concluded, and I quote, that there are significant human rights problems in Australia that must be addressed, ranging from our relationship with Aboriginal and Torres Strait Islander peoples, protection of privacy in the digital age, and the treatment of minority groups. The significance of this should not be understated. A clear scaffolding of rights is both a condition and a sign of a decent society. As Professor Avishai Margalit observed some time ago now in his affecting book, The Decent Society, the enterprise of a decent society has meaning only relative to a society with a clear notion of rights. We are regrettably some distance from that notion. Australia remains the only liberal democracy not to have a national act or charter of human rights protection. And at a state level, New South Wales lags behind other Australian jurisdictions. The ACT introduced a Human Rights Act in 2004. The Victorian Charter of Human Rights and Responsibilities was introduced in 2006. And most recently, Queensland introduced a Human Rights Act in 2019. The New South Wales Bar Association has long advocated for human rights legislation at a state and federal level. And we have long sought to highlight the significant failing in New South Wales and Australia's protections for human rights. We have called on both political parties to enact a statutory Bill of Rights for New South Wales, taking into account the experience under the Victorian, ACT and Queensland legislation. The Association advocates for a New South Wales Human Rights Act that will require all legislation to be interpreted with Australia's international human rights obligations. Those include the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination against Women, and the United Nations Declaration of the Rights of Indigenous People, among other conventions. The human rights in these conventions have not, on the whole, been specifically incorporated into domestic law, with the exception of the prohibition on discrimination on the grounds of race, sex, disability, and age. The Association has also recommended that a range of specific rights be protected, taken from the Victorian Charter of Human Rights and Responsibilities of 2009, including but not limited to equality before the law, right to life, protection from torture or cruel, inhuman and degrading treatment, freedom from forced work, freedom of movement, protection of privacy and reputation, freedom of thought, conscience, religion, belief and expression, and peaceful assembly and freedom of association. The Association has also called on parties to provide for all proposed legislation and subordinate legislation to be scrutinised by Parliament against international human rights standards, to strengthen the mandate of the Parliament's Legislation Review Committee, to carry out that scrutiny and to allow for a declaration that legislation is incompatible with such standards. There has recently and encouragingly been an increasing social and institutional momentum behind human rights reform. At the two-day Free and Equal Human Rights Conference in June this year, 700 human rights advocates from across Australia gathered in Sydney to call for an Australian Human Rights Act. We'll hear more about that event this evening from our panellists. Likewise, the Federal Parliamentary Joint Committee on Human Rights, among a range of recommendations, called for the establishment of a Federal Human Rights Act. The inquiry held 6 public hearings across 5 capital cities and received 335 public submissions and 7 confidential submissions. We eagerly await the federal government's response to that inquiry. And finally, the New South Wales Law Reform Commission is currently reviewing the Anti-Discrimination Act. Under its terms of reference, the Commission is considering whether the Act could be modernised and simplified to better promote the equal enjoyment of rights and reflect contemporary community standards. For all of these reasons, today's public lecture is timely. While many people in this room have been calling for reform for many, many years, indeed decades, the pressure on the New South Wales government is mounting. And as today's lecture will show, there is a clear roadmap for reform for the New South Wales government. Our hope is that government will listen to the experts in this room. Can I then introduce our hugely esteemed first speaker? The Honourable Michael Kirby, AC, CMG, is an international jurist, educator and former judge. He served, among many things, all of which I will not list, as Deputy President of the Australian Conciliation and Arbitration Commission, Chairman of the Australian Law Reform Commission, Judge of the Federal Court of Australia, President of the New South Wales Court of Appeal, President of the Court of Appeal of the Solomon Islands, and Justice of the High Court of Australia. He is currently Editor-in-Chief of the Laws of Australia. Welcome, Judge.
Thank you very much, President, for that introduction. Your Excellency, members of the faculty, judicial colleagues, past and present, and fellow citizens. I do apologise for being late. I hate being late. I am absolutely fastidious in punctuality. The judges may sometimes be wrong, but they're never late. They're on time. But there was gridlock, as you've heard, in the city, and I was ultimately advised by the taxi driver to get the train. There was then gridlock in the train service, and all in all, there was a great hurried rush from Redfern Station at a pace that I haven't done since I was a student at this university, actually doing lectures in this very spot in the Faculty of Economics. I did an economics degree after my arts and law degrees, and so I used to come here to the Stephen Roberts lecture theatre, which was on this place. So I take a deep breath, I gather my thoughts, I show my respects to the First Nations people whose plight continuing in our country is very relevant to the matter that we are gathered to discuss. And I start with telling you that these 3 days, that's to say Wednesday, Thursday and Friday, are pretty busy in my agenda for human rights. Yesterday, I came to this very law school punctually and delivered a speech to the Stone Institute, which celebrates the work of my great teacher of jurisprudence, Julius Stone, who was Challis Professor of International Law and Jurisprudence at this law school. That was an interesting exercise in company with Justice John Baston, a very distinguished and able lawyer who got to know Julius at the University of New South Wales, where he went after he concluded his service as Challis Professor at this university. And there were some excellent questions from the students, and I think it'd be a good thing if I curtailed my much delayed speech so that there is time for questions, because yesterday that was terrific. Tomorrow, Friday, I go to Apia in Samoa. That is where the CHOGM meeting is taking place with the Commonwealth heads of government. And the King is going to be there as head of the Commonwealth, and it's going to be a very friendly discussion amongst the politicians, not so friendly on the part of civil society, because the representatives of civil society are gathered by the Commonwealth Foundation, of whom I am one, are going to take the governments of the Commonwealth, 54 of them, to task for their failure to have regard to universal human rights in the context of the Commonwealth. And in 2009, I was appointed to a group called the Eminent Persons Group of the Commonwealth to draft a report on the future of that institution, which is a most interesting relic of empire that is still going strong and still very much admired and used by the politicians who are in office around the Commonwealth. And it seemed to me that once the Commonwealth moved away from allegiance to the monarch, which was the glue that kept the empire together. That was the common element, that we were all subjects of the crown. Once that was no longer a universal feature or even a majority feature of the countries of the Commonwealth, something different had to be found that would explain, justify and strengthen the bond of the Commonwealth of Nations. And that was agreed by the members of the Eminent Persons Group. I said, what we need is a charter of the Commonwealth, which set out the values of the Commonwealth. And everybody agreed. They thought that was a great idea. And they said, well, of course, we can't draft it. We don't have the time, and we've got to go home to our home countries. And I said, leave it to me. And so on the very long flight, which most people in this room will have done, from London to Sydney, I was sitting in the Qantas jet in business class, and I didn't have any paper with me. So I repeatedly called for Qantas paper napkins. And on the Qantas paper napkins, I began to pen out the structure and content of the Charter of the Commonwealth. V.I. Lenin once said, and he had reason to know, that the enemy of action is the blank page. And I therefore tackled the blank page. I filled all these paper napkins. Qantas was out of paper table napkins for the rest of the flight. And I gave it to my hard-pressed secretary, Sarah, and she can understand my writing, and she typed it up when we got back. And to the next meeting of the Commonwealth, rather modestly, I handed the draft that Sarah had typed up for the Charter of the Commonwealth. And so that charter was greatly influenced by the Universal Declaration of Human Rights, and it set out the principles of the Commonwealth. There were some additional issues relevant to life in the Commonwealth, particularly environmental issues which profoundly affect the countries of the Commonwealth in the Pacific and in Bangladesh and in other countries, and other issues of community concern. And all of these were gathered together in the Charter of the Commonwealth, drafted by me. At the end of the meetings, the other members of the Secretariat and of the Eminent Persons Group said, this looks a very good draft to start with, and we should put this and we should annex it to our report. We should make the point that we are not endorsing this as the final word, but if the enemy to action is the blank page, the great danger in an institutional setting in leaving it to some later future undefined time is that there are always 1,000 reasons for nothing to be done. And so the draft that I did was annexed to the draft report of the Eminent Persons Group. And that was presented by us to the CHOGM meeting in Perth, where Julia Gillard had just been elected Prime Minister, and her Minister for Foreign Affairs was Kevin Rudd. It was a very friendly meeting, and Kevin Rudd did a great job as the Foreign Minister, and he supported strongly the work that we were doing. And ultimately, the Charter of the Commonwealth was referred to the officials of the heads of government. And so they got to work on it, and they produced a redraft of it, which in parts is substantial, in other parts not so substantial. But it's very interesting, in a way, to be present at the birth of this idea. I was very pleasantly surprised at how similar the draft that was produced by the officers was influenced by the draft which were on those paper napkins in the Qantas jet. The net result was that the draft was commended to the Commonwealth of Nations. It was worked on by the Secretariat. There was then a great enthusiasm to get things done in order to have something to show for the Commonwealth meetings. And so in the corridors of the annual meeting of the foreign ministers of the Commonwealth, representing the heads of government, convened in New York, generally in September, the foreign ministers, in consultation with heads of government, agreed to the draft that had been prepared by the officials. And that draft became the Charter of the Commonwealth. In a brilliant article, which has been published in a journal called Round Table, I drafted a comparison of the two documents and something of the history. Then it was sent back to London, and Her late Majesty, Queen Elizabeth, came to a meeting on Commonwealth Day in the following year to sign the Charter of the Commonwealth. And that was the end of that process of preparation. But in later articles, I've had to compare to what extent has the draft influenced Commonwealth action. Because if it's just another document, it really is not of great use, and it may even be of a nuisance, because it might distract from the Universal Declaration of Human Rights, Eleanor Roosevelt's great document, which is the progenitor of most of the work since 1948, when it was adopted in Paris at a meeting of the General Assembly, which Dr. H.V. Evatt, Minister for External Affairs of Australia, was chairing as the third president of the General Assembly of the United Nations. So far, Evatt is the only Australian who has been elected to the presidency of the General Assembly, and he made it his business to get it through the General Assembly. And the Universal Declaration is a wonderful document. It's not the first human rights instrument of English-speaking people, because I suppose you could count Magna Carta, in a sense, of 1215, as an attempt by the barons to set out some basic principles which would be higher than the ordinary acts of Parliament. And likewise, at that critical moment in British constitutional history in 1688, the so-called Glorious Revolution, when the Commons of England were asked to substitute William and Mary as the monarch for James II, the terms of their doing so was that those monarchs would jointly sign the Bill of Rights of 1688. And that was the first English-speaking specific general statement of rights. And that became the foundation of the American Bill of Rights after the American Revolution. The revolutionaries said, we want a Bill of Rights to keep tyrants under control. And they turned to James Madison who was the most hostile to a Bill of Rights. And he had said, who will be so bold as to draft the rights of the people? And so they thought, well, he's just the sort of person we want to have to do it. And so it was committed to him, and he drafted the Bill of Rights. And if you speak to any American lawyer or judge, they cannot believe that we don't have a Bill of Rights. They cannot believe this is. I'm not referring to judges of long past who were radical. I'm talking about the very conservative judges who are on the Supreme Court of the United States today. They cannot believe that you can get by in a country without some basic fundamental rights to keep the show on the road. So when in Australia we came to our constitutional arrangements, there was a serious debate during the meetings of the group of settlers, all men, who had to decide what the new Australian Constitution would involve. And one of those, extremely influential, was Andrew Inglis Clark, who was a delegate from Tasmania, a very great man who just missed out, for reasons I won't trouble you with, to be appointed to the first or second High Court of Australia. A very great man and a great lawyer. And he urged that we should have a Bill of Rights. And he grasped the opportunity to try to advance what he thought he probably wrote on the paper napkins of the Tasmanian Club or of some other place where when they met to discuss the terms of the Australian Constitution. However, the head of the Constitutional Convention, who later became the first Prime Minister, Barton, said, no, we don't, this is not something comfortable to the British tradition. The British tradition is one of relying on parliaments and on a judiciary which will have some creative role, but very much under control and subject to the role of Parliament. And that was the view that was ultimately taken by the delegates to the Australian Constitutional Convention. It was something that might have gone the other way, but the affection to a sovereign Parliament was very strong in the minds of the settlers and of English-speaking, particularly colonial settlers, and that is what we did. We did have a few provisions in the Constitution, as you know, that provide for some human rights. There aren't many of them, and the default of express provisions in the Constitution, the High Court and other institutions, the federal parliament, have created what are roughly equivalent to basic rights. And they've done it in legislation and sometimes by the High Court in interpreting the constitutional document in a way that was creative but legitimate as being based on the text, which is always the concern, to go back to the text and keep to the text as the source of your legitimacy. So, during my growing up, I came to learn, partly in this place or its predecessor, the problems of the hypotheses upon which that approach, the approach of Barton and of his colleagues, rested. It rested on a great faith in Parliament to solve all problems, or at least all important problems. and it rested on a great faith in keeping the judiciary out of political controversy, and therefore avoiding the large, broad language that was typical of a Bill of Rights. And these two principles were allied with something that was probably never mentioned, and that was that the provisions called Bills of Rights were generally favoured in Catholic countries, Roman Catholic countries, because they had a strong belief in and teaching about natural law, that in the nature of human beings, there are some fundamentals that inhere in their nature. And most English-speaking people at the time of Federation would have none of that. Most of them were Protestants, and they said, we prefer to put our faith in Parliament to fix things up. So that was the debate. And it wasn't a debate without some substance. There were different points of view. They were expressed, and in the end, the parliamentary obsession controlled the outcome of the Australian Constitution. But that still left things that Parliament wasn't fixing up. And as I grew up, I began to see these things. I began to see, for example, the Australian White Australia policy. And when I was at this university, I became the president of the Students' Representative Council, and I was sent to Nigeria, leading a student delegation, a friendship delegation. I've always been strong on friendship. And the net result of that was I went to Nigeria and I met the governor of the eastern state, Sir Francis Ibian, and he only took about 3 minutes to get to his topic. How can you Australians justify your White Australia policy, he asked. And I never had to do that because it was a bipartisan, strong policy going back to pre-Federation. And I said, well, Your Excellency, every country has its own racial composition and its own history and its own background, its culture, often mixed up with religion. And we have that and we protect that in our own way. But it left me rather unsettled. And when I came back to Sydney, increasing numbers of students at that time, I'm talking about 1962, were becoming rather questioning. They didn't need Sir Francis Ibian to make them question. They just looked into themselves and looked into the increasing number of students coming to this place under the Colombo scheme. Suddenly, we were beginning to see people who were not white. And that led to a lot of people asking those questions. Now, did Parliament fix that up? Well, it ultimately fixed it up in about 1967 when we had a referendum and in the Holt government, and other steps were taken thereafter by the Whitlam government. But those two governments effectively abolished the White Australia policy, but it's been step by step ever since. And you can't tell me that there aren't still remnants in Australia of the White Australia policy. It was very deep and very unanimous for a very long time, and there weren't mechanisms in our Constitution that could be used to combat it. As well as that, at about this time, my grandfather, he was my step-grandfather, had joined the Communist Party. And that wasn't a good career move at that time. But the Menzies government moved to abolish the Communist Party and ban it and put civil prescriptions on communists. But the High Court of Australia, led by Sir Owen Dixon, by majority of 5-1, held that this was not constitutionally valid, that you had plenty of power to do things for what communists did, but not for what they believed or what they thought. And the result of all this was that the Communist Party Dissolution Act was struck down. There was a referendum. The referendum did not agree to the Menzies government proposal to give the power to the federal parliament. And so that was a victory for Parliament, in a sense. And that people would say, there you are, that's what happens. We fix things up in our way, which is in a legislature. But I had this little, which had been given to me at the Summerhill Opportunity School, where I was a little boy in primary school. And this isn't the actual book, but it was like this. Dr. Evatt in Paris and in New York had sent it to all public schools in Australia. He obviously thought that the children would take it home and show it to their parents and they'd all vote for Dr. Evatt, which unfortunately, or fortunately, they didn't. But this was what we were given by our teacher. My teacher was Mr. Gorringe. I didn't know his first name because we never knew teachers' first names in those days. It was Keith. And Keith Gorringe gave me this book, and I got into my mind the first paragraph. All persons are born free and equal in dignity and rights. Those wonderful words, written by a Canadian whom I later met, John Humphrey, who was a professor of law at McGill University. He was a secretary to Eleanor Roosevelt's committee. So I'm a sort of link of all of you to that committee and to Eleanor Roosevelt and to John Humphrey, who wrote in beautiful copperplate writing. I know that because Canada offered a stamp to honour John Humphrey on his centenary. All persons are born free and equal in dignity and rights. And there is the idea. That's the central idea. And the central idea is then elaborated by what we now call civil and political rights, and in the one document by economic, social and cultural rights. But we in Australia have remained very resistant to this. I don't think anybody today would explain it by reference to religious differences or the natural law tendency of Roman Catholics as against Protestants. But it is this haunting dream of a sovereign parliament that will fix everything up. And this is where yesterday's conference is relevant, because Julia Stone said Parliament doesn't fix all things up, and the judiciary have a role to fix things up where Parliament has failed to do so, and it will often fail to do so where it involves a minority, because by the nature of a Parliament, it is responding to a majority. And that was Jules in explaining what he called the leeways of choice that judges have. It's not a complete free slather, but it's a useful way of improving and changing the system. But it's not as good as having a foundational document that gives a mechanism of government the power and the obligation to fix things up. We still have problems with race in Australia. We still have problems with First Nations people. Please remember that the High Court of Australia in Mabo versus Queensland, number 2, decided the Mabo decision, Mabo number 2, by reference to a human rights principle. At page 42 of the decision in 175 CLR, the High Court turned to what Justice Brennan said was the one principle of international human rights law which is universally condemned and is not acceptable, and that is you cannot deprive people of rights by reference to their race. You look at it, 175 CLR 1 at 42, which is where that passage stands, and it's the key that unlocked the door, and it was pure human rights reasoning. But if we hadn't had that, and if we'd had a different court, we might not have changed that. But keep it in mind when you hear we can't have activist judges. Sometimes, Justice Dean said, when the land below is parched and fallow, there's a need for a bit of activism, and there is a need for the waters to come down and to provide for change. So this is just a thumbnail sketch of a long saga that goes back to 1215. It has many steps on the way, but it wouldn't be a bad thing if children in our schools were given a document like this. And when later in my growing up, I discovered that my sexuality, it was a comfort to me to know all persons are born free and equal in dignity and rights. And ultimately, we, by what seemed to have been very slow steps, changed most of the laws relating to LGBTIQA++ people. But it took a long time because we didn't have the mechanism for the judges or for the other institutions, and the other institution, if Parliament, often took the view that this is just not a priority. When I was on the High Court of Australia, my partner, who came down to Canberra with me, we were really good family values. He was always there when we were sitting, and he was not given a travelling allowance. And so I raised with my colleagues, should we have it, proposed this to the government, and the High Court, as often happened in those days, divided, and it was 3-3. And I said, well, I can't vote in it because I'm affected. But Justice Mary Gaudron, who was a great champion of human rights, said, I'm not doing this just for you, Kirby. I'm doing this for the principal and for all other people who are similarly affected. So get used to it. You got to vote. I said, very well, Mary, I'll vote. And it was put up to the government, the Howard government, but the message came back, this is not a priority. And it was when the Rudd government was elected that within 2 weeks, legislation was introduced, which went through Parliament virtually unanimously. So I question what was the priority that had prevented that happening. So Australia is still a backwater, and our instruments of democracy are good. Our Parliament does a lot of good work, but there's a need to improve the mechanisms. And the way in which we could do that would be by adopting both federal and state bills of rights, charters of rights. They won't replace Parliament. Parliament will probably have to have the last word. It won't be in the Constitution. It will be ordinary legislation. It's nothing to be afraid of. We're muddling our way slowly towards something similar, but too slow and too unfair for people who are left out. And that's basically what I came to say today. It's the result of a lot of thought about our history and the errors of it and the need to do something better and to have an instrument which we can use to teach children in the next generations that we live together with certain principles of commonality. And that is something which we need and is overdue. So that's it. Thank you.
Thank you, Judge. Can I now invite Hugh de Crester to speak? Hugh commenced his 5-year term as President of the Australian Human Rights Commission on the 30th of July 2024. Before joining the Commission, he was the CEO of the Europe Justice Commission. Prior to that, he was Executive Director of the Human Rights Law Centre and Executive Officer of the Victorian Federation of Community Legal Centres. Hugh has also served as a Commissioner of the Victorian Law Reform Commission and a Director of the Sentencing Advisory Council. Hugh.
I had to go get a prop because Justice Kirby had a prop as well. My Victorian Charter of Human Rights from 2006, and from last week, the ACT Human Rights Act. Sorry, last week I received a copy of the 2004 piece of legislation. There we go. Great to be here and see such a great crowd, and nice to connect with friends who I haven't seen for a while here in Sydney. I acknowledge the Gadigal people and their ancestors and elders and their continuing connection to culture and to these lands. And I acknowledge the pain of this week's anniversary of the Voice referendum and the pain for those Aboriginal, the strong support from Aboriginal and Torres Strait Islander communities who wanted a greater say and voice in issues that affected them. And I also acknowledge the particular importance of strengthening human rights protections for First Nations people, given how their human rights have been trampled since the start of colonisation. A New South Wales Human Rights Act will help First Nations people, and it will help all people in this state. Human rights are the blueprint for a decent, dignified life for all. They are the key to creating the kind of society that we all want to live in, and they reflect values like equality, freedom, respect, dignity, kindness, thinking of each other, and looking out for each other. When human rights are respected, our lives are better and our communities are stronger, healthier, safer and more prosperous. The Australian Human Rights Commission under Professor Croucher's leadership, my predecessor, made significant progress in advancing the case for a national Human Rights Act. The Commission's landmark Free and Equal reports highlight the inadequacy of our existing protections and the need for reform, and they provide a roadmap for that reform. I think Professor Croucher described it as giving the reform on a platter to the federal government. Silver platter, I think. While Australia's promised to protect human rights set out in all the major international treaties, as we've heard, these treaties aren't directly enforceable in Australian law. Our promises in the global stage are not backed up effectively here in Australia. Our human rights protections are patchy and our human rights safety net is full of holes. We live in one of the most safe, stable and prosperous countries on the planet, but that safety, stability and prosperity has not been shared. There are countless examples in our history of human rights failings, from the White Australia policy to the criminalisation of homosexuality, entrenched sex discrimination and more. Sadly, there are many contemporary examples also. At the federal level, the Royal Commissions into robo-debt and the abuse experienced by people with disability and in our aged care system have exposed serious human rights failings and show how our existing systems are inadequate. Our federal failures include the criminalisation of Australian citizens trying to return from India during COVID, and the police raids on the ABC and a journalist's home for their role in exposing war crimes, potential war crimes, alleged war crimes. A National Human Rights Act will help to change this. The model proposed by the Commission for a National Human Rights Act was largely adopted by the recommendations recently of the Parliamentary Joint Committee on Human Rights in their report handed down in May. Importantly, our proposal for a National Human Rights Act focuses only on Australian government bodies, or in human rights language, public authorities. Public authorities like Australian government departments, the Australian Federal Police, Centrelink, Medicare, the National Disability Insurance Agency, and more. It won't apply to state and territory bodies. In this way, a National Human Rights Act will complement the existing human rights protections in the ACT, in Victoria, and more recently in Queensland. And this underscores the importance of having proper human rights protections in every jurisdiction in Australia, including New South Wales. We need comprehensive human rights laws. I've lived in Melbourne most of my life, and most of my career as a community lawyer, a human rights advocate, and law reform has been since this 2006 piece of legislation came into existence. And I've seen firsthand the power of the Charter, State-Based Human Rights Act. I've been involved in hard-fought, important human rights cases using the Charter. But I'm firmly convinced that the biggest impact the Charter has had has been way away from any courtroom. But working properly, what human rights acts or what the Charters do is they prevent human rights breaches from occurring in the first place. Human rights acts do this by requiring governments and public servants to do two things: properly consider human rights and act compatibly with human rights when they're making decisions, when they're developing laws and policies, and when they're delivering services to people. This, in turn, fosters better understanding of human rights and a culture of respecting rights, considering people's rights. Human rights acts force governments to think about human rights before they act. The experience from Victoria, the ACT, Queensland, New Zealand, UK, Canada, etc., is that where human rights acts have had the biggest impact is in developing better human-focused laws, policies, and services. Most of this work is done very quietly as part of the normal business of government by requiring governments to ask, what's the goal we're seeking to achieve with this law or policy? Is it going to intersect? Is it going to restrict people's rights? Is this justified? And in looking at that, are there less restrictive ways to achieve that goal? And that test, what lawyers call the proportionality test, is an incredibly powerful public policy test to help governments to make the right decisions and to help communities and people to judge governments as to whether they're making the right decisions. Doing that is human rights in action, delivering good human-focused laws and policies, decisions and services. But people have to have the power to take action to protect their rights. If they don't, governments don't take human rights seriously. That's what's happening at the federal level. We have a Parliamentary Joint Committee on Human Rights. It's doing good work scrutinising human rights laws, and ministers and departments are ignoring their work, typically. Some changes that are happening, but so people have to have the power to take action. Rights without remedies are not rights at all. Again, most of the good work in Victoria, ACT and Queensland where there is the power to take action is done well away from any courtroom by people raising complaints with agencies through the Ombudsman in Victoria, the Human Rights Commission in Queensland, and more recently, the Human Rights Commission in the ACT. The Human Rights Law Centre, my old work, has got an excellent publication called 101 Case Studies about Human Rights and how Charters, Human Rights Acts have helped people protect their rights. Some of those are in courtrooms, some of those are in complaints to ombudsmans and human rights commissions. Some of them are just people raising their human rights because this is such a simple piece of legislation. It's about 50 pages long. It's like the Universal Declaration. It helps people understand their human rights and helps people stand up for their human rights. I could talk about many cases. Maybe I'll do that in the question time if we've got time. At the national level, I'm confident we will get a Human Rights Act. Support for a Human Rights Act is strong and it's growing. Amnesty International, Human Rights Law Centre and others have done polling showing there's strong support. That support grew during COVID. People who had never had their right, had to think about their rights, were suddenly being treated in the same way that First Nations communities or migrant communities, for example, were being treated. And they said, where are my rights to protect me from what they saw as unreasonable government interference in their rights? And so we saw support for a Human Rights Act grow. There's an excellent campaign with over 100 organisations behind it, First Nations organisations, disability, aged care, human rights organisations, ACOS, etc. I'm confident it will happen, and I encourage you to get behind the movement here for a Human Rights Act in New South Wales to complement what will happen federally. Thanks.
Thank you, Hugh. The final part of this evening's programme, can I check that you can hear me? Is this working? The final part of the programme is a panel Q&A. Can I introduce the other participants in that panel? First, we have Trent Glover SC, who's chair of the New South Wales Bar Association's Human Rights Committee. At the bar, Trent has a diverse practice concentrating primarily on public law litigation at first instance and at appellate level around Australia. And Carmel Lee is a barrister specialising in commercial law, equity, conflicts of law and human rights. She's a member of the Human Rights Act for New South Wales Alliance and the New South Wales Bar Association's Human Rights Committee. Can I start with you, Judge, as seems fit and proper? How might a state Human Rights Act affect an individual's day-to-day life in New South Wales?
Well, one thing I learned very early in going to conferences like this over the Charter in Victoria was that sometimes the Act works in mysterious ways. And one of the points that I found very persuasive was Gemma Varley, who was the first parliamentary counsel in Victoria. She said, we have to vet legislation as to whether it complies. This is giving it a tick of good housekeeping if it does apply, and drawing to the notice of Parliament and the government and the community if it doesn't apply. And therefore you find most problems that arise are solved without going to court because we can deal with them. But occasionally the government says, no, we're not going to change the law. This is justifiable. We can justify it. We can take it to the electorate and justify it. And that was done by Mr. Brumby's government in Victoria over a provision that allowed arrest of people and frisking and searching. And the government said, or Parliamentary Council said, this is not conformable. The government said, we don't care, we're going ahead with it. And it had to be taken in the next election and was debated. I think the government was returned, but it was transparent. It was opened up. Likewise, Professor Gerber in Victoria points to the fact that the document can be used in teaching children and teaching the community in programs on the media and informing people of the content, just as Mr. Gorringe informed me with the Universal Declaration. So it can inform ordinary people in their everyday life by affecting their everyday activities, and a federal statute or federal provisions would not deal with the issues which are overwhelmingly dealt with by state law. And I just made a note, the criminal law, the local government law, environmental law, anti-discrimination law, education law, and garbage collection law, or laws of every kind, little things that affect ordinary people. They tend to be state law, and therefore if you don't deal with them and you only deal with the big grand issues of federal government, it's going to leave a lot of people behind.
Thank you, Judge. Hugh, you seemed more optimistic about a Federal Human Rights Act than state legislation within New South Wales. What, if any, effect do you think momentum for federal legislation has upon a campaign for human rights legislation in New South Wales?
I think it's all intersecting. So it was great for the national campaign that Queensland got its Human Rights Act, and it just builds a momentum. So I know there's various state and territory campaigns around the country. I think Tasmania got close a while back. WA has had an inquiry into a Human Rights Act. So it'll be interesting to see which jurisdiction goes next. Obviously, as the Australian Human Rights Commission, we're focused on the federal jurisdiction. with the Commission's Free and Equal report, with the Parliamentary Joint Committee report, with the campaign, with the survey support, with the Disability Royal Commission. So the Disability Royal Commission also recommended what they called a Disability Rights Act, essentially through its terms of reference focusing on people with disability, said we need this kind of thing, looking at a Human Rights Act for people with disability. The disability sector has responded to that to say we don't want rights just for people with disability. There is a joint letter written saying we want rights for everyone. We want to get behind a National Human Rights Act, and our Disability Rights Commissioner, Rosemary KS, has strongly supported a Human Rights Act. So the momentum is there.
Could I just ask a little question? Because like the President, I was a little bit surprised that you seem very confident about this, that something will be done. But I worked with Gareth Evans, who went off into politics in the early days of the Law Reform Commission, and he knew a lot about politics. He knew a lot about how Parliament works and how things can get done or not get done in Parliament. And he said a human rights statute has to be done in the earliest days of a government in Australia, or it won't succeed. It requires strength, courage, and a little bit of risk-taking. And our politicians seem to be a bit averse to risk. So what is after the voice, what is the source of your optimism? I want to know.
Gareth Evans is the source of my optimism. I've seen him present on responsibility to protect and how the role he played to, this is true story, by the way, the role he played to try and achieve that reform at the international level. And he had a strong confidence about that reform. It will not happen if we're not confident about it happening. I'm under no illusions about how hard this will be. The politics is difficult. I think Gareth Evans, when he was Attorney General, got a Bill of Rights or a Human Rights Act through the House of Reps, and it was never went through the Senate. So we had a national human rights consultation in 2009, 2010, which recommended a Human Rights Act. The Rudd government didn't carry through with that recommendation. They did set up a human rights framework, which the Abbott government effectively dismantled, except for the Parliamentary Joint Committee. So I'm under no illusions that this will be easy. But if you look at Queensland, for example, that was hard. And I talked to the Queensland attorney one time and I said, thank you for putting in economic and social rights in the Queensland for, first time properly, not like still a modest version of them. And I said, why did you do it? Thank you for doing it. And she said, it was the right thing to do. And so sometimes there are these windows of leadership where, and I was in Parliament, I've spent a lot of time in Parliament in my first 2.5 months in this role. And at one stage we were walking down the corridors of Parliament, we're talking about a Human Rights Act, and we just stopped and went, why is this so hard to say we're talking about fundamental basic human rights for people in Australia, and yet it has been so hard to get that change. And so we need to change it. And I'm confident it will happen. When it will happen, I'm not sure, but hopefully in the next term of Parliament.
Can I just jump in there and say, I was particularly interested in your observation, Hugh, that a lot of the genesis for a federal Human Rights Act has come from the states. I have always been interested in the general Eastern Seaboard ignoring the ACT's Human Rights Act, which came a long way before everything else. Then you had the Charter in a big jurisdiction like Victoria. Now you have the Queensland Human Rights Act in a relatively big jurisdiction, like third biggest jurisdiction in Australia. How significant would a New South Wales Human Rights Act achieve or demonstrate to the Commonwealth Parliament that a federal act was necessary?
I think it would be extremely significant. The most populous state, and I've engaged with New South Wales politicians in my old role to argue for a New South Wales Human Rights Act. I think I've met with Attorney Generals or Shadow Attorney Generals in every jurisdiction in Australia to argue for a state and territory-based Human Rights Act. And we know the territory, we know the arguments for and against. Justice Kirby's outlined them. and we need the political leadership to make it happen. And I was sort of reminded in a meeting last week or the week before when we were talking about what was it in Queensland that made the Human Rights Act possible, and it was a constellation of factors, but part of it was great excesses by the Queensland government under the Newman government around particularly the excesses of the bikie laws, where they were doing things like making people wear pink jumpsuits in prison. There were ridiculous uplifts to particular sentences. And people, and there was an independent MP, Peter Wellington, who was the balance of power, and he felt passionately about putting some legal standards that government needed to comply with, and he was a key reason why the Queensland government moved ahead with a Human Rights Act.
Thank you. Trent, can I ask you a question? How can organisations like the Bar Association advocate for change and influence policy to achieve a Human Rights Act for New South Wales?
Thanks, Ruth. And I'll probably jump off what the judge has said and what Hugh has said. The Bar Association's Human Rights Committee has a very diverse and challenging remit. We monitor legislation, of course, and policy for human rights issues. Another aspect of our terms of reference is to raise awareness amongst barristers and the legal profession and the public about human rights issues. This lecture being part of the fulfillment of that term of reference, I hope. To give you an example of a reach of recent government overreach, is the recent knife wanding laws. Now, the Bar Association came out and opposed that law, which sees the police have the power to designate certain areas as designated areas, usually stadia, shopping centres, in the wake of an increase in knife attacks. In fact, the statistics in New South Wales are, even including those attacks earlier in the year, knife crime is actually decreasing. But the effect of these laws is that police will have the power to choose anyone without reasonable suspicion or reasonable cause and submit them to a search that will determine whether they have a knife or an offensive weapon on them. Now, obviously, that can impact marginalised communities, First Nations people, and build that intergenerational mistrust that people have with law enforcement agencies. What the Bar Association was able to do was say, we oppose the law. Now, almost every Bar Association submission I have written says this law reform proposal engages important human rights. These are important human rights under the International Covenant on Civil and Political Rights, or the International Covenant on Economic, Social and Cultural Rights. How good would it be to be able to say, this engages the important human rights contained in the New South Wales Human Rights Act? How much more powerful would a submission to government be if we were able to say that? And that gets back to the judge's point that parliaments are not infallible. If we have the ability to influence lawmakers and legislatures' minds in that positive way, we should be doing it.
I think also the leadership of the bar is very important. And you know, in the old days when those three earlier iterations of the Human Rights Bill were introduced into the federal parliament, basically my recollection is that the bar really didn't favour it. And that was a time when the bar was overwhelmingly, if not entirely, male. The bar has changed and is changing, and I think that's a good thing. And your leadership and that of others in the Bar Association has really helped to put a wind behind this, because I still think what Gareth said to me so far long ago is true. It's a pity that there's always this talk about it, but not having a model And I tell you, I was very disappointed in the parliamentary committee that looked at the proposal of the for a federal act, that the minority report was comprised only of members of the Liberal Party, and they were, I think, unanimous. I think no Liberal stepped out, and when you've got a political division like that, it's very hard to achieve significant change. So I think that should be a target. The party of Robert Menzies was not a Conservative party. It was a Liberal party. Like all parties, it did some good things. It was the party that introduced Commonwealth scholarships and got me and both my brothers to university. And so the Liberal Party should not be opposed to this. And you've got to work on trying to get people in both sides of politics to see the value of this and that it's not threatening, but it's useful.
Thank you, Judge. Carmel, can I ask you a question? As I mentioned, you're a member of the Human Rights Act for New South Wales Alliance. Can you tell us a little about what that is? And also, how can organisations like the Alliance advocate for change and influence policy?
Sure. So the Human Rights for New South Wales Alliance is, I hope that, is this working? Yep. Is a group of about 47 civil and community group organisations. There's too many to name in that list, of course, but it's co-convened by the Australian Lawyers for Human Rights. And I note the immediate past president, Kerry West, is here tonight, and I acknowledge her work in that as well. And the New South Wales Council of Civil Liberties. It also includes a number of other organisations such as the Human Rights Law Centre, Young Lawyers of New South Wales, and the New South Wales Bar Association. The main aim of that organisation is to build momentum for a Human Rights Act in New South Wales. We've seen similar campaigns in other states as well. What we've seen in other states is that importance of a grassroots movement. Trent and other panellists have discussed the importance of making submissions and representations to government and encouraging government and educating government to see proposals that they might put forward for legislation through a human rights lens. And it would be terrific if we had a New South Wales Human Rights Act that we could immediately point to, rather than, as commentators have described, this ad hoc legislation around Australia that protects rights. So a key thing that the New South Wales, that the Alliance for the Human Rights Act for New South Wales does is twofold. One of those is to assist in making those submissions to parliamentarians and to work behind the scenes in relation to that and to educate them in a human rights framework. But the other factor is incredibly important, and that's by generating that grassroots movement. Anytime that we've received that change has been made in this area, it's because of a grassroots movement, and it has to be coupled with representations to Parliament. In 2006, in Victoria, 61% of those surveyed believed that they already had a human rights charter. This was before Victoria had a charter, or that it was protected in the Constitution or a Federal Bill of Rights, which we know is not the case. In that process, they went through a process of educating the public, and that included small group consultations, reaching out to different interest groups and small interest groups as well. And over that period of education, by the time the submissions came in, 84% of those people who put in submissions were in favour of the Victorian Charter. So we know that engagement and persuasion is incredibly important, and that's where organisations such as the New South Wales Human Rights Act for New South Wales Alliance comes in. So public education is key, and consultation is key in generating that from a grassroots movement, and that hopefully transforms the political will in this landscape as well. I note the comment about optimism on the panel earlier, and I thought I might address that. I second the comments that Trent made earlier in relation to optimism that Hugh made as well. And another thing that I wanted to raise is that what we've seen is we've seen the passing of the ACT Act, we've seen the passing of the Victorian Charter, the passing of the Queensland Charter, the Queensland Act, but we've also seen that those have been amended over time as well. So over time, we've built upon those acts, and momentum has continued to grow over that period. So that gives me optimism in this area.
Thank you, Carmel. Now, this is not part of the programme, but in the spirit of democracy that's pervaded the discussion thus far, does anyone in the audience have a question they want to ask anyone in the panel? Okay, the first hand I saw was the man in the middle with his hand still in the air.
Thank you very much. Probably the country and the culture most famous for talking about rights and various rights acts and bills of rights and so on is America. Americans love telling you about it. But when I look at America right now, materially what's going on the ground, this is not striking me as something that we'd want to imitate, and it doesn't seem to have been avoided by Americans spending hundreds of years formulating various documents and refining them about the rights that they have. So what's going on? Thank you.
Well, of course, a lot of things that are going on in America, and including their presidential system. I mean, poor things, they missed out on the development of the Westminster model, which happened in the first 30 years of the 19th century. And therefore, they were stuck with King George III and the model of the president who's everything. And this is their basic problem. I don't think their basic problem, it was the Bill of Rights of the United States that broke down the segregation of schools. It was the Bill of Rights of the United States that broke down miscegenation and that laid down fundamental rules of fairness in interrogating prisoners. So there are very good things. No system is perfect, but we have a gap at the moment. And we're not, no one's saying we'll get it in the Constitution anytime soon. But to get it in a statute and have an override provision if necessary, as happened with Mr. Brumby, it would get people thinking and it would teach kids at school. Professor Gerber in Melbourne found by contrasting the knowledge of basic rights of citizenship in Massachusetts children and Victorian children that there was a big gap in Australia. They don't have Mr. Gorringe that gives them a copy of the Universal Declaration of Human Rights. We do in Victoria have the Charter, but we need to spread that as an example throughout the country. And I think we shouldn't despair, but I do think we've got to work on the Liberal Party in the federal parliament, because this shouldn't be a matter of party politics. And it was disappointing to me to see that they all lined up against the federal model that Professor Croucher was putting forward. And we've got to try and win people over, and it's a bit urgent. And if it can't be done now, then we should have everything in place for the next time there is a government with determination and with confidence. Confidence is very important. Courage is very important. And we don't really have that as often as we should.
Would anyone else like to answer the American question? Are there any other questions from the audience? Oh, sorry.
So thank you, everyone. The Commissioner mentioned that part of the issue is providing power to the people in fighting for their rights. And my question is about the contribution of barristers, seeing we have members of a bar association here today, about whether they believe they've done enough to be advocates for human rights. For instance, in relation to the robo-debt, the bank, Royal Commission, the banks, I really did not see too many barristers standing up and defending those people who had no money to defend themselves. Allied to that question is, does the Bar Association have, as part of their protocol, to appoint senior counsel, some credit given to people who do pro bono work or who have a specialty in fighting human rights issues? And my last question is, would the President consider giving to each and every new barrister being admitted a copy of His Honour's book? Because I can tell you, you don't get it, and I'm a barrister. Thank you very much.
Can I try and deal with them, Sarah, Adam, and briefly? The first question as to what barristers can do. Barristers conduct themselves in various capacities. As barristers, we can act for clients. When that's done, as you know, in our professional capacity, we're subject to the cab rank rule, but we all do have the freedom to act pro bono. It is critical that all members of the bar, and particularly senior and visible members of the bar, do accept pro bono briefs. I do it myself. We encourage all senior members of the bar to do so. The other mechanism we obviously employ, which Trent has addressed this evening, is the advocacy work through the policy department of the association. That work is reasonably unrelenting. The Human Rights Committee and the Criminal Law Committee make endless submissions throughout the year, and it is all done through a voluntary commitment from barristers who are otherwise exceptionally busy. So that the policy work of the association is not something, the depth and strength of which you really appreciate until you see the work of the staff of the association and the sheer extent of the voluntary commitment given by very busy barristers.
Can I just add to that? The barristers become judges, and the Banking Royal Commission was conducted by Justice Hayne. Now, Justice Hayne and I didn't always agree. He was a rather conservative judge, I thought. But boy, when he got onto that Royal Commission and he turned all his very great skills and intellect and experience, he really got to the bottom of it, and he had help from counsel who were assisting him. And that was a really success story, I think, the Royal Commission on banking. I think that was, I have to take my hat off to Justice Hayne, though it hurts to have to do it.
Can I gratefully adopt the judge's answer to the second question and say nothing further? As to the third question, I'd be delighted to give copies of the Universal Declaration on Human Rights to barristers. At the moment, the Chief Justice of New South Wales is encouraging us to give a copy of Constant Guardian Changing Times, which is a history of the Supreme Court, which we are giving gratis to all new barristers for a number of years to educate them in the institutions of law and the importance of the treatment of those institutions of communities like First Nations individuals. So we have recently started initiatives of providing learning materials to barristers when they commence at the New South Wales Bar. But I'm not averse to the Universal Declaration. Oh, sorry, yes, sorry, that's something that's close to my heart. Aunt Hannah Tompkins, who was one of our independent members this year, one of the criteria in the protocol is contribution to the community as an Australian barrister. That has regard to pro bono activities, including through the LARS scheme, which we facilitate at the Bar Association. And last year we introduced for the first time as an essential criterion for the taking of silk, a demonstrated commitment to diversity and bullying, not commitment to bullying, but to the avoidance of it, which has to be shown at least through the requirement of a mandatory CPD and preferably through a much more rounded contribution to diversity and preventing bullying at the bar. So these are all also issues which have had some attention for some time at the bar, but have recently been developed to try to address some of the concerns we have about mistreatment and incivility in the community of the bar and in community more generally.
Diversity is so important. That's why some people used to hate women being in judges and being at the bar, and people hated LGBT. They really, even this morning outside State Parliament House, there were people wandering around saying no to equality, and similarly with race. Anybody who was a bit different. But when Charles Darwin wrote his book, Origin of Species, chapter 2 of it is the rule of variation. And Darwin taught that the way we evolved was not because of our similarity and sameness, it was because of variation. And therefore, the work of anti-discrimination and variety and diversity is a very important feature. And I've seen it in my own career at the bar, and I pay a tribute to the Bar Association for fostering it.
I was just going to add very briefly, there's a genuine issue about making sure people have good access to representation to engage in Royal Commissions. I remember being at the opening hearing of the Bushfire Royal Commission in Victoria, and every electricity company in government was lined up with all of their senior counsel and law firms. And victims of the fires who'd lost houses or loved ones had very little say. And we argued for a public advocate service, if you like, and I spoke to the Bernie Teague about it, and it didn't end up getting taken up by government, but it did get taken up by the federal government when the Institutional Child Sex Abuse Royal Commission was brought in, and that service is called No More, and it's still going. So genuine issue, and there's ways to do it. Dundale Royal Commission also had free legal representation. Uruk Royal Commission, where I worked in Victoria, free legal representation for people engaging with the Royal Commission.
And can I just acknowledge there are solicitors from No More in the audience and the CEO of No More, for whom I do some pro bono work from time to time. Just because you mentioned the Robodebt Royal Commission, there were no barristers involved in advising the government in that. The failing in that system was that internal legal advice was not sought to be second counselled outside. It was only 4 years into the scheme that, in the context of an AAT case, Clayton Utz was briefed and said the scheme's illegal. Then the Solicitor General was briefed, who also advised the scheme was illegal. Now, would a Human Rights Act have affected that? I think the answer's got to be invariably yes.
We've got to get strategic. Clayton Utz have traditionally had quite a lot of connection with the Commonwealth Government and with the Liberal Party and with Liberal members of Parliament. So we've got to get strategic and get Clayton Utz to advise us on how we can get this message over. Don't be threatened. This is something which is a basic justice, and a good society looks after the vulnerable and the diverse, not just the multimillionaires.
Can I ask for one final question from the audience before we end for this evening? In the second row.
Thank you. I'm Philip Tarmingis. I'm a member of the Queensland Parliamentary Advisory Panel on the implementation of the Queensland Act. I'd just like to make two brief points and ask the panel if either of these have been considered in your discussions about a New South Wales Act. The first is with respect to application. In the Queensland Act, there is a convoluted section, Section 59, which, when you work through the tortured syntax, means that despite the fact that governments are obliged to consider human rights issues, an individual cannot bring an action directly under the Act unless it is linked to another breach of some other area of law. It's a piggyback provision. Now, this means that the Queensland Act is nothing like a Bill of Rights. It's a step forward, but don't let yourselves be lulled into a false sense of security that's the next best thing to a Bill of Rights. In Queensland, it's not. The other thing is legal education with respect to human rights. There's been a great deal I've seen written in this. I was away for 17 years practicing overseas, but there's been a great deal written here, but I can't see there's been a lot actually done with respect to education, particularly of lawyers, most of whom have a very shonky appreciation of human rights, particularly people of my generation. What I would point out also to those of you involved in New South Wales is that, as Michael Kirby said, so much of this is at state level. When human rights are taught in law schools, it tends to be as a hermetically sealed unit within the curriculum, with not very much appreciation of how this will, in fact, apply to criminal law, to land law, to property law, etc. And in Queensland, that is becoming a problem. And I would just pose that to the panel.
Do any members of the panel want to comment on any aspect of that?
I'd like Philip to tell us, what has the opposition in the current election in Queensland said about the bill? Is there any suggestion?
They haven't said so much. The main mantra of Mr. Crisafulli, the leader of the opposition, we go to an election on Saturday week. The main mantra is adult crime, adult time. In other words, putting children into jail. The Queensland Act, in fact, has an opt-out provision, and it's with respect to children's justice that the Queensland Parliament exempted provisions about sending young children to jail because it's electorally popular at the moment, because there's this perception that crime by juveniles is out of control. With respect to human rights specifically, no, the opposition has said very little.
It's important to remember with the Charter, there were people in the then opposition Liberal Party and National Party who wanted to repeal the Charter. But Mr. Baillieu, was that his name? He said, no way, it's not going to happen under my watch. And I hope that somebody is thinking about this and working on it, because it would be a bad step if instead of going forward, we go backwards.
Indeed.
Hugh, did you want to say something?
Yeah, sure. Yeah, very briefly, the piggyback clause is like the ACT model is much better. The UK model is much better. We've recommended that in Free and Equal report. The Parliamentary Joint Committee has adopted our recommendation. There should just be a simple direct cause of action. There should be a low-cost, accessible dispute resolution mechanism. It should be complaints to Australian Human Rights Commission or the Queensland Commission, depending on your jurisdiction, should be able to not have to go through that piggyback procedure.
Thank you. Now, having said that was the last question, I had intended that the young woman in the second row ask a question, and given that she's a young woman, I'm going to let her speak. You had a question you want to ask, and it can be the final question.
Thank you very much. It was raised by His Honour earlier that constitutional drafters like Barton were against a Human Rights Act because they championed this notion of a responsible and representative government instead. But we've seen time and again that our current government is capable of being neither responsible nor representative at times, and this is a sentiment held in particular by my generation. So aside from responsible and representative parliament, what leg would a campaign against a Human Rights Act for New South Wales actually have to stand on?
Well, I don't know that I know all the ramifications of the question, but the experience of overseas, including in English-speaking countries, including in the many Commonwealth countries that were given by the departing British a Charter of Rights, which they hadn't themselves given to the colonies, there's a tremendous amount of material, you know. It's a tremendous body of jurisprudence. It's an enormous development, as Philip Tarmingis indicated, that it's going on in many countries. People of my age don't really know much about it, but younger lawyers have got to learn about it. So I think giving them this might whet their appetite, the Universal Declaration, and I think we've got to be very strategic about the political parties, because otherwise nothing much will happen. I think it really is important. But politics in Australia at the moment is very factious, and that's a problem that has to be overcome. So we've got to turn all the brain power in this room onto that problem and address it. Otherwise, we'll be still talking about this in 20 or 30 years' time, when fortunately I will not be late. I just won't be here.
Can I ask you to thank all of our panelists, the Honourable Michael Kirby, AC and CMG. Give us